Yes, welcome back to the No State Project Live, episode 108. I think I got that right, but it is February, good Lord, where the hell is my mind? But it is April 24th, 2019, live from the Fortified Compound in Mesa, Arizona. Glad to be with you here today. I want to thank everybody again for the continued support of the show. If you'd like to help support the show, you can do so at markstevens.net or markstevens.cells.com. And if you are being attacked by a bureaucrat, you want to learn how to effectively defend yourself. And I've got three updates, three success stories to add. I am going to still continue what I've been doing if the content is there, where if there has been a train wreck reported, I will include the train wreck with the success stories, because I don't want anyone getting the false impression that these things are easy and they always result in a ticket being tossed out. Yet it's a 3-to-1 ratio because we tend to win more than we lose. So look forward to that. But we do have, so if you are looking to effectively defend yourself and want to be able to replicate the success that I have had and other people have had, then markstevens.net. Check out we have consultations available that I still do. Also have templates available and a full support system where not just where I answer emails and field questions on Skype, but also here on the air, 4 hours a week of Anarchy Radio. So it's anarchy, government abuse, and defending yourself effectively in court. So check out markstevens.net for that material. And all the material here on the show is free. So if you do have a question, you call in. Now, I did title this show tentatively. It was about triggering American capitalism. Because much like when you go to court, okay, there's a disconnect between what I'm saying, okay, the defendant, let's say, in court, and what is actually being heard by the audience or somebody, the judge. And so just like judges don't actually listen when you have an argument, because they don't consider, especially in a tax case, that we actually have valid arguments. See, I've actually been told, not by a judge, but by IRS agents, that a frivolous argument is any argument that actually contradicts or negates an argument from the IRS. So someone at the Franchise Tax Board in particular told me any disagreement with the Franchise Tax Board is a frivolous argument. They actually came across as if they actually believe that, which is, wow, that's some staggering stupidity there. So one of the things that I talked about, and it's, look, and I've had some very, very few people criticizing, hey, when are we going to get to talking about jurisdiction? Isn't the show about court? The court stuff is a big part of the show, but remember, the show is about anarchy. This is the first Wednesday show where I've got the banner back, and we don't have the choppy video. So the show, as I've said for a very long time, is about getting to a voluntary society. So I laid out in the description of the show, we're talking about anarchy, government abuse, and defending yourself in court. So defending yourself in court, really, really important. But it's not the entire focus of the show. And going to court is just a means of educating people and getting people to argue better, spot bad arguments, and be able to stand up for themselves and see these people for what they are. Because a lot of people that come to me, I'd say a lot, but there's a small percentage of the people that come to me for help with traffic that are not anarchists. In fact, I have to say, there's probably a good chunk, if not half the people that contact me for help on traffic cases and drugs or possession, stuff like that, taxes. They are not coming to me as anarchists, but they see that there is a very well-established track record of being able to get these tickets thrown out. And one of the unfortunate convincers of them, because the logic is sound, the facts are sound, of anarchy, but the convincer seems to be, for a lot of people, is going in and the way they're treated by people who claim to be protecting life, liberty, and property. To be able to go in and watch a judge literally ignore your entire motion and make a ruling even after he is admitted to not even reading it. Okay, that's a very common thing in traffic court. It's far more common than I even like to admit. But that's the reality. We have to deal with the facts. And we've had people, and I've been in this situation myself, and we've had people report the judge admitted to not even reading the motion. I've had a judge in Scottsdale say he's going to deny a motion that wasn't even filed yet. He did toss that out because I had stood up and I said, wait a minute, did you just say you were going to deny a motion you haven't even seen yet? And he slipped back. Yeah. And I looked at Tony Parro, the court reporter. I said, Tony, did you get that? Yes, I did, Mark. I said, Scott, let's get the hell out of here. We're done. And I said, we'll see you in the appellate court. And we walked out, and the judge wound up actually tossing that out, which was really nice. But this is a very common thing where the judges just completely ignore your argument. And I'll go into just some detail here. But in California, in a tax case where we were going against the IRS because the Anti-Injunctive Tax Act, which for the first time in my memory was actually acknowledged by defense counsel. So district counsel for the IRS, or the assistant U.S. attorney there in California, a deputy, actually acknowledged in their paperwork that there is a narrow exception to the Anti-Injunctive Tax Act. But they try to argue that we just raised a frivolous argument and we didn't overcome our burden. So this individual goes into court a few days ago. I think it was Monday. No, actually it might have been Thursday or Friday. But he went into court, and the judge made no mention of the Anti-Injunctive Tax Act, had no mention whatsoever even of the IRS's actual defense, which was the Anti-Injunctive Tax Act and sovereign immunity. Didn't mention that at all. Instead, launched into an interrogation, which had nothing to do with the pleadings. And you just left there standing like, that's not the issue before the court. The issue before the court is, do these facts, as alleged, which you have to take as as true and most favorable to the plaintiff, do these facts put this case within the Anti-Injunctive Tax Act's narrow exceptions? That was the only issue on the table. Instead, the judge launches into interrogation. Do you have a job? Do you work? Do you have a job? And then made a decision that he had to pay taxes. But you completely ignored the fact that the IRS admitted to not having any evidence to support their legal claims and didn't need evidence. He completely ignored the single issue before the court, which was, again, ignoring, the entire complaint. And this is what you expect. So the same thing happens when the few handful of people, like our friend Tom in the Big D. I'm being accused by several people, it's only a handful of people, of being a communist because what I did was I thought was an honest critique of capitalism and socialism. And I'm called a pinko and a communist. I'm an anarchist. I believe that do no harm, live honestly, injure no one, give every man his due. I think that's a pretty good ethical standard to live by. You know? Yeah, the guy who I'm quoting didn't do that so much. But still, that's it. I have never advocated violent revolution, violently taking over the means of production and violently taking over government so that we can then, once we have control of the means of production and government, then we can, or using the government to violently seize the means of production so that we can get to a stateless, governmentless society. That's never been a proposition that I've put forth. That's never been something I've advocated. So just like this scumbag judge, last week in federal court, completely ignoring the single issue before him, which was, do the facts that you have to presume is true and most favorable to the plaintiff, put this case within the narrow exception of the Anti-Injunctive Tax Act. Instead, just saying, oh, you owe taxes, you have a job, which was completely irrelevant to the issue before the court. And just like these scumbag judges, these Tom and two or three other people just assume that because I'm critiquing capitalism and showing a factual problem with capitalism that leads to tremendous harm worldwide. Commie! I got news for you, Raymond. Capitalism is not all that it's cracked up to be. And this is why I think Americans tend to get triggered when you do something like critique capitalism, where the example and I'll use the same example. You've got OPEC, you've got the oil industry deliberately cutting production. And I go through the private ownership of the means of production is the keystone of capitalism. That is its defining feature. Not the fact that you use capital, use money. That's come on, we're not 5 years old, eh? The defining feature of capitalism is private ownership of the means of production. Now, market manipulation goes directly to that. They own the means of production. They can cut the production if they want, and they can cease production if they want, because they own it. And so the idea that they can't take something that they own and deliberately manipulate the market and say that that is not capitalism is just pie in the sky American bull. Market manipulation is absolutely built in and baked into capitalism. It is an honest, fact-based critique of capitalism. So pull your head out of the sky and stop thinking that capitalism is this wonderful, magical thing that will solve all the world's problems, because it is an absolutely perfect philosophy. Absolutely perfect. No, Americans are triggered by that because they've been conditioned to think that socialism bad, capitalism good, and that there's no good form of socialism. And then to turn around and say, which I think it's either bad argumentation or just flat out dishonesty, to turn around and say that any critique of capitalism is wrong because we've never had true capitalism, because there's always government intervention, but by the same token saying you can accept all criticism of socialism, even though there's always been massive government intervention. You can't say that socialism was the boogeyman in let's say, Russia, because you had a totalitarian lunatic in control. You had a totalitarian, brutal regime. And to turn around and say that it wasn't the totalitarianism that was the problem, it was socialism. Oh, totalitarianism is great if you just have if you just don't use socialism. You can have totalitarianism if you have capitalism. I mean, come on. If you can't accept a critique on capitalism because there's massive government intervention, then the same thing goes for socialism. You can't have it both ways and be logically consistent. It's just wrong. So, also there was a criticism that somebody had posted regarding one of my videos regarding the applicability of the Constitution. And somebody is trying to say that the burden of proof is on me. There, I'm looking at the comments now. I'm sorry, I hadn't seen that. So the criticism is this, that if somebody says the Constitution does not apply, that the burden is on me, for example, to actually show that, that's true. And I said, well, no, the burden of proof is on the one making the claim. So somebody who's saying that the Constitution does apply to everybody and does create obligations, the burden is on them to actually prove that that's true. Now, I can still, and I've done this every single show, and I'm going to do it again here today. Somebody's saying that market regulation is socialism. That is not necessary, because you have regulated markets now. With capitalism. So, a regulated market you can have with socialism, and you can have it with capitalism. A regulated market does not necessarily always equal socialism. That's, again, the defining factors between socialism and capitalism is ownership of the means of production. If it's social, if it's common, then it is socialism. If it's privately owned, that is capitalism. That's how you separate the two. There are different aspects to each, that go, but the defining features are the ownership of the means of production or the company. So, it's not accurate to say regulated markets equal socialism. That's not how it works. That's not accurate. The burden of proof. And this is really important when we get into court also, because prosecutors will always dishonestly try to flip the burden. There's a common thing. If you don't think that the Constitution applies, you have to prove that it doesn't. You have to prove that. No. The burden of proof is on the one making the accusation. And unless they have facts that, if accepted as true, tend to prove the proposition, they haven't met their prima facie burden, and the burden doesn't shift. But even if the burden, the thing is, I can still show the evidence disproving the claim, even though the burden is on them. And that is this. We'll start with the facts. Government is nothing more than men and women forcing perfect strangers to give them money on a threat of jail and death. Okay? For those who say that the death is hyperbole, you're wrong. You're wrong. You are absolutely dead effing wrong. They have a force continuum. If you defend yourself, they will kill you. So, the fact that it's under threat, duress, and coercion, the fact that they have a prison system is enough to show that they are immoral and unethical, and that they are a criminal organization. And given that they are a criminal organization, the fact that they claim a written instrument applies to everybody doesn't hold any water. The fact that they are just men and women forcing everyone to give them money negates the claim that their rules and their constitution applies and creates any obligations. So I can still meet a burden even though the burden's not mine. So there's that. And, we keep getting back to this thing. Mark, I don't know we have seen socialism run its course, but capitalism has not. We have seen state capitalism, but not Adam Smith's view on capitalism. Thoughts? Well, that's true. True. We've always had violent interference. We've always had a partnership with government, whether it's socialism, with services such as the roads and the hospitals, electricity, power and water. We've always seen it. The fire department, it's almost always been that way for a few hundred years at least. The same thing with capitalism. And the thing is, the history of capitalism is pretty damn bloody. If you look at, a lot of what was going on, with the extermination of the Indians had to do with the railroads. We have the phrase banana republic for a reason. So do I have to mention the Dole Company and the devastation in Guatemala and in Central America? Because, and who were the ones that were behind, making Q8 anyway? It was American and British capitalists. Capitalists, again, they make a market, they do a cost-benefit analysis. I've mentioned this on the show before, where they will knowingly put out a product that is dangerous and will hurt people, and it's easier to just settle wrongful death lawsuits. Well, Mark, that's not those are capitalists, though. And they're using government to help protect them. No doubt. But to say that there's no honest critique of capitalism, no. You have to stop with this American BS, American exceptionalism, that capitalism is the be-all, end-all. It has flaws. That doesn't mean it's not a system worth pursuing. I didn't say throw the baby out with the bathwater. I think keeping the mixed economy like we have now and getting rid of the government. Yeah, I'm not talking about forced communal ownership. Come on. I'm talking about free association and voluntary. Anarchy. Live honestly, injure no one, give every man his due. I never said, Tom, forced anything. I wish we could, look, this is an honest situation where somebody is taking my position and completely misrepresenting it. I'm not sitting here and crying like another professed anarchist who says that everyone that disagrees with him is strawmanning him. You actually are doing that here. Plus, my only counter argument doesn't just rest on straw man, but when it's appropriate, I will defend it on those grounds. So, Tom is quoting Lysander Spooner: "The Constitution has either authorized such a government as we have had, or has been powerless to prevent it. In either case, it is unfit to exist." Yes, absolutely right. Right on the money there. But again, on the burden of proof, do not let people in or out of court pull that lawyer move of trying to flip the burden of proof on you. Don't fall for this trick. It's a very common tactic. What evidence, I can ask, what evidence do you have to support your legal claim that just because I'm physically in Arizona, your constitutional laws apply to me? And I fire back, what evidence do you have that it doesn't? Oh, I don't know. I have your own actions and inability to support your own claim. Can we get back to the actual issue here? See, and you could just respond with that. Hey, the fact that I'm talking to you right now and you've dodged the question and you have had ample opportunity to lay out your facts and the logic proving your claim is true, those are my facts that it doesn't apply. You cannot support your claim. And it's one of the things I'm bringing out. I'll discuss in more detail. Something going back to the tax case. Due process, as far as I know, okay, doesn't give a damn what a judge thinks about whether you owe taxes or not. Due process is concerned with whether the one making the claim actually has evidence to support that. The fact that the judge thinks you're guilty of sin is supposed to be completely irrelevant. The judge has to believe you're guilty of sin because the prosecution's evidence, the one making the claim, the facts show that you're guilty. Not the judge's personal opinion. And I'll say this before I move on to the calls. A frivolous argument, even by the court's, opinions, a frivolous argument is when somebody argues without evidence and brings it in bad faith and doesn't think they even need evidence. Now, who are the worst offenders for this? The single worst offenders are those called government. The second one are those lackeys and shills who make their money supporting such garbage. So it's just like with Captain Bonespur. Everything he talks about and accuses other people of doing, he is guilty of. And here, when they start screaming autistically from the rooftop, frivolous, they are the ones who are most guilty of doing that. Always keep that in mind. A frivolous argument is knowingly arguing without evidence because it's bad faith. That is frivolous. And sometimes I think these people are getting paid by the word. Well, the more times I say frivolous, if I just keep saying frivolous enough, they'll agree. And they're right. Because the judges, who used to be prosecutors most of the time, spent a lot of their days screaming frivolous like an idiot. Frivolous, frivolous, frivolous! Is my claim that the IRS, through their own admissions, cannot support their claim that that there's jurisdiction, that the laws apply. Is that frivolous? You have to look at the supporting facts. When I have the agent on record admitting that, it's not frivolous. It's absolutely right. But they can't address the actual issue, and if they do, they just say they don't have to prove that. And that is by definition a frivolous argument. That is a frivolous argument. So, let's get to the calls here. Stuart, I got the Ireland shirt on. For Stuart, change your banner to this, anarchy is not frivolous. I could do that. But, we got, Edwin from Georgia. Welcome back to the show.
Hey, Mark, can you hear me now?
Damn it. I can hear you now. Well, welcome.
Okay, great, yeah. How you doing, man?
Hey, I'm doing all right. Maybe people will understand. I can get 100% of the people understand me now that I'm not a communist. We can hope.
Yeah, I'm just calling you to give you good news, man.
Excellent.
And I want to express my profound gratitude for your input and your help. The motion to dismiss for denial of speedy trial was granted, and I had the case dismissed on yesterday morning.
Excellent.
So I sent in the proof of it to your Skype, and I also sent you an email of the information
Very
of
nice.
the dismissal. So yeah, maybe you have not seen that.
Oh, I'm glad to hear. Am I getting your name wrong or correct? If I need to.
No, I am Laurence, so but my brother is Edwin. So yeah.
Okay, I got it.
My
I kind of
brother
figured
is
that.
Edwin, I'm Laurence.
Okay, I kind of figured. Well, I appreciate you calling in and reporting to us on that. And I guess I do have to go the extra step and saying there's it's plausible that this had nothing to do with your defense. That the court was just bogged down. They weren't able to get to your case, and they did the right thing and they tossed it out.
Yeah, they kept bringing me over for calendar calls, and then when I filed in this motion, but they had a hard time with me during my motions hearing. Yeah, the judge did not like, my presence there, and then he set me for trial. And when I filed that motion, that is when I went for my trial, and then he was like, the state decided to dismiss, your case. So, I would like to read out, actually what they said, which is very funny and senseless. They said that, in the dismissal, they said, while this court has jurisdiction, in this case, and probable cause existed, the state does not believe it can prove the case as charged beyond reasonable doubt. So that is the statement they put in there.
Yeah, I remember reading that. I do appreciate you sending that, and I will redact the personal info, and I'll get that posted, with the other two dismissals I referenced earlier. Is that, look, all right, so let's just examine this. Let me see how many callers we got. All right, we only got one other call, so we got time. Is that plausible? I think we could all agree that, we may be able to take the prosecutor at his word, that he was being completely forthright and being honest. That's plausible, right?
Yes, sir.
Right. Now, let me ask you, unlike, and I think I got reference to somebody saying that a critic has already dismissed the dismissal and now, is it logical, is it reasonable of us to, and especially for you, since you know the context better than any of us, to conclude that is the only plausible explanation for the dismissal?
Yeah, I have no other one, Mark. This is all I have. Yeah, this is the only possibility.
Wait. You think it's the only possibility is that the prosecutor was telling the truth, that's the reason why he tossed it out, that there was evidence of jurisdiction and probable cause?
Yeah, nah, I don't. I mean, they are just making it look good over here, because they are still claiming that they have jurisdiction and probable cause, which does not exist. Because they can't really prove the second part of it, which they say they can't prove it beyond reasonable doubt. That right there holds some water.
The thing is, you filed a motion to dismiss. You did the discovery request, right?
Yes, sir.
Now, did they actually provide facts that would prove, even at a prima facie level, that the Constitution, a written instrument from 200 years ago, applies to you and creates obligations?
Nope, they didn't. They just repeated the claim and sent me copies of the citation and the codes which they claim I violated.
So
that was all they sent.
So we know from you, and you're in this, you've got personal knowledge of this. Unlike the critic and unlike myself. I mean, I have personal knowledge of the actual written dismissal because you sent me that, but I'm talking about the context of, the situation that led up to that. You have personal knowledge. I don't. Neither does this critic. So given the fact that when they had the chance after all these months to present this evidence, they couldn't do it. Did they name a witness? But did they name a witness that had personal knowledge? See, that's the thing. They couldn't name a witness with personal knowledge of the matters they're testifying to.
They did. The discovery response they sent to me, they stated the police officer's name as the witness with personal first-hand knowledge.
But did he have? That's the thing. How can he have personal first-hand knowledge of the matters he's testifying to, namely that the laws apply because you're physically in Georgia and that you violated them when there wasn't any evidence in the record for him to testify about and have personal knowledge of?
Yeah, that is it right there.
So using the more of the context, we can say that if the prosecution had evidence, now he's admitting he doesn't have the evidence to prove it beyond a reasonable doubt. So what this hinges on whether he's telling it, now I'll take him at his word there. Okay? I still don't believe, I don't believe that he had proof, given what I know and what you've told me, that he had evidence to even make a prima facie showing. So that's what he's leaving out. And I think that's perfectly reasonable and rational for us to say that that is a plausible explanation for why he threw it out. It wasn't just he couldn't make it beyond a reasonable doubt. He couldn't make it even at a prima facie level. So I think if we're being honest, if the critic is being honest, you still have to allow for my explanation based on the context that you've given me that there is another plausible explanation for it. And I'll throw this in. What I know about prosecutors, not the most honest bunch. Why should we conclude that this prosecutor, after all this time, that this prosecutor is telling the absolute truth here? Really? I mean, come on. I'll admit that because of what I've seen prosecutors do, I generally will assume that they're scoundrels. Okay? But given what you've told me about this, I think that's an accurate description.
Yeah.
So
I agree with you on that, Mark.
Did you actually speak to this prosecutor and confront him directly on these facts?
Many times. He is the one I told you pointed out the physical location that my physical location is evidence that they lost and they caused. Then I asked him the example of my presence at Walmart, making me an employee of Walmart, and he ran away saying that he had a lot to do and left me standing there and left and ran away. And then again, when I confronted him the last time in court, asking him about the existence of Georgia before 1777 and how those written instruments create obligation on me, and if it was magical. And the prosecutor was honest enough to tell me that yes, they apply magically. And told me that it was a contract and was throwing the contract and all of that,
So, given this and all and you're reporting with personal knowledge of this, I think he was being sarcastic when he agreed it was magical because he flat out cannot meet his burden. The fact that they walked away from you, the idea that he's going to say that the Constitution is a contract, which has no factual support whatsoever, that is enough for me to see. He knows he can't make even a prima facie burden. So he'll try to make himself look good in the dismissal by just saying, I can't prove it beyond a reasonable doubt. No, you can't. What, you can't prove beyond a reasonable doubt that the code applies? You're damn right. You're absolutely right. You gotta agree with him on that one.
Yeah.
And now some may parse that and say, well, that's not what he meant by that. Well, given the more context that you had personal, contact with this prosecutor, I think the more probable explanation for this is they knew they couldn't even make a prima facie case. They knew that you were going to ask these questions on cross-examination. And it was easier just to throw it out under the guise of, I can't prove this beyond a reasonable doubt. Yeah, you can't prove the code applies beyond a reasonable doubt, and you can't prove beyond a reasonable doubt. Because of that, you can't prove beyond a reasonable doubt that he violated the code. It seems pretty simple.
But Mark, I told him, like outrightly clear, I was like, sir, the biggest mistake you can make is to let this case go to trial and you bring that police officer and put him on the stand for me to cross-examine him. And he asked me what's going to happen. I told him you are going to impeach your own witness. And he got so emotional. How can you say that? I'm not going to do that. I asked him, did the police officer file a valid course of action? Is it valid? Well, what he filed, we accepted it. I said, so it's irrefutable. You know, he was just being emotional right there. So I told him straight up, the biggest mistake you will make is taking this to trial for me to have an opportunity to cross-examine him. You would impeach him.
Yes, you're absolutely right. And even if he didn't believe you, Laurence, to me, it doesn't matter. Go ahead and doubt. Think I'm just puffing up, when I'm beating my chest here, that you're going to impeach your own witness. Almost every single time, with two lone exceptions in 20 years, they always say, objection calls for a legal conclusion. The witness is not qualified to testify. They do it every time. Every time, but two. So, yeah, they will impeach their own witness. And yes, even Randall, that lawyer up in New Hampshire for it was a state taxing agency. They put an offer of proof in that the witness does have personal knowledge. You object to, or I object to it. He puts him on the stand anyway. And once I ask him for the facts,
that's what they do.
Yep. Once I ask for the facts that their legal determination was based on, they start screaming, objection! Witnesses can't testify. I told you that, you jackass, and you put them on. It's just like they said at the end of The Devil's Advocate, and you put that lying bitch on the stand anyway. We tell
exactly.
You still.
He's the one who got emotional and told me I wouldn't accept anything for an answer and walk out of the courtroom.
Yeah. Oh, you won't accept it, and yet he admits publicly he can't make his case beyond a reasonable doubt. Fungo, you prosecuting, you guys over here. So this is nice vindication. Again, congratulations. I'll get that posted probably tomorrow. I really appreciate you not only defending yourself and standing up for these people and challenging them and getting these great admissions from them, but actually going the distance and having them toss it out. So appreciate that.
Yeah. Thank you so much, Mark, man. All thanks to you, and I really do appreciate all you do, man.
Well, I appreciate that, Prego Paisan, and stay in touch.
Okay, man. Thanks.
Appreciate the call. I'll get to the other call in just a second. I want to reiterate, and I'll do this in the separate video, but it's very important to keep in mind when you go online and people are calling me a scammer. Anyone who says that there's only one explanation for something that happened, and especially when they are not a part of the proceeding, that there's one and only one. That's so rare to have only one explanation. But those who say there's one explanation and one explanation only have an agenda. And the critics of mine that turn around and say that, like with here, that there's only one exception, one explanation, are being dishonest. There are more than one plausible explanations for the dismissal. And I think my explanation carries more weight. Not because I'm trying to sell something, but because that's what the evidence tells me and that's what the facts say. He was able to confront this prosecutor a number of times. He actually came out and said that I know sarcastically that they magically apply, but he made the claim that the Constitution, a written instrument, was a contract. That is freeman on the land, sovereign citizen garbage. Trash. What's he going to do? Argue that? No wonder he dismissed. No wonder he realized he couldn't prove his claim beyond a reasonable doubt. Because his claim isn't just, did somebody violate the code? You have to show the code applies beyond a reasonable doubt. Because logic dictates if you cannot first prove the code applies beyond a reasonable doubt, you can't prove it was violated. That's basic logic. Yeah, and someone's saying here, Caspa, they say Mark's a scammer, but refuse to call in and simply destroy his claims. Yeah. If someone out there like that, those lawyers, honestly believe that I'm hurting people. Yeah, I'm hurting Laurence. You believe that I'm honestly hurting somebody, why not call? I'm even willing to go on another live broadcast. You could completely humiliate me. And depending on what show it is, you can post that. And because it's probably a far larger show than mine, someone types my name into Google or even YouTube, you're going to get the first hit. And people are going to be able to see me being humiliated. They'll be able to, if I'm really a scammer, just call the show, confront me. I'll embarrass myself. Even if I just hang up, you will be able to use that to make it impossible, virtually, for anybody not familiar with my work to ever purchase anything from me again. So that goes out to anybody who thinks I'm a scammer. You can not only just call me live, I don't have the budget, nor do I want to screen calls. You can call in and as a live broadcast. You can record it from your end. I can't stop that. Even though this isn't an LRN broadcast, you can record the statements. You can record everything that goes on. But people don't do that. And yeah, the one critic in recent memory that did call failed to show where I was wrong. He never shut the hell up, but he interrupted me at almost everything I said, which is just a stupid lawyer trick. And I regret ever allowing him to do that, but he certainly didn't show where I was wrong. So that's an open invitation to people who think I'm scamming people, that I am knowingly peddling information that's wrong. And, oh yeah, I had to do a barter for this banner because I have such a budget. Because I'm scamming so many people. So, yeah, the vegetarian anarchist auditor, why are they doing this tomorrow? Well, there's only a handful. There's less than 10. There's just a few people that are, maybe 3 people that are absolutely beyond, the pale and hang on every word. It's not a big deal. I have very, very few actual critics. And that's because I deal with criticism on the show. I don't, so anyway, let's get to the calls. He's been very patient. Looks like a new caller, which is good. Area code 604. You're live on the No State Project. What's your name? Where you calling from?
Hey, Mark, it's Mac, calling from Vancouver, British Columbia.
Hey, nice.
Just from Skype. How are you doing?
I'm doing really good because I get calls like I just did from Laurence, and it kind of helps somewhat when I have a train wreck like what's happening in California. It's still, that's bad, but it's nice to have, it's nice to have, still a 3-to-1 ratio.
Oh, California? I missed that part. Were you talking about that off the top?
I was talking about that near the top because what happened was in the district court in Northern California, a judge who unfortunately is a paisano, although technically I never like to see that it's a fellow Guinea that is doing the tyranny, but federal judge completely ignored the single issue on the table and ignored due process, fairness, and just did what federal judges do and ruled against somebody despite overwhelming evidence in their favor, ignoring every rule of due process in the book in the process.
What was the matter? What was the charges?
Well, it was somebody's trying to stop a garnishment, a 100% garnishment, and we have evidence, and I'm part of this. I actually did most of the talking with the agents. We have multiple agents admitting that they had no evidence to support their claim of jurisdiction. They had no evidence to support their claim a tax liability was created. They admitted this, and some of them are on record saying they don't need evidence. And so we bring it into court, and they challenged it. They wanted it dismissed on grounds of the Anti-Injunctive Tax Act. Now, when you file a motion to dismiss, you are admitting all well-pleaded facts. The judge has a solid due process obligation to accept all well-pleaded facts as true and in a light most favorable to the plaintiff, which is the guy I'm helping. And the only issue was, do those facts taken in a light most favorable to the plaintiff put the case within the narrow exception of the Anti-Injunctive Tax Act? Instead of discussing that, the judge launched into an interrogation of the guy that had nothing to do with that issue and then ruled against him.
Wow.
But the critics will say, I'm just an idiot. Well, you shouldn't, you're an idiot. Okay, I will accept that mantle for purpose of argument. How does that defeat the fact, and how does that change the fact that the judge didn't address the single issue before him that day, and doesn't address why he refused to comply with the basic principles laid down by the Supreme Court that you have to accept the facts in a light true and most favorable to the plaintiff. So even if you accept that I'm an idiot, that does not explain why the judge violated basic principles of due process.
So you guys appealing that now?
Well, I did, and I might make available in the video, after I redact the names, my response to this garbage, which is a motion to reconsider. I personally think, give it, what's happened already, I don't think it's worth the $450 filing fee. I don't think the appellate panel is capable of applying the principles of due process in a tax case. So I don't think that there's there's probably no remedy by appeal.
Okay. Yeah, well, I've got, one hearing next week. I was feeling pretty confident. I've been listening to all your shows and, but I wasn't taking notes. Now I gotta go in next week, and I'm just, getting a little afraid if, when these tyrants start derailing you and kind of asserting jurisdiction and, kind of assuming that jurisdiction applies and kind of hitting me out of, left field, with what I'm not mentally prepared to answer.
Okay.
So,
well, okay, well,
yeah, no,
it's a code violation, right?
Yes.
Okay. Is it civil or criminal?
It's motor vehicle act.
Okay, it's probably criminal. Have you filed the application or the motion to dismiss and the discovery request?
I did. So for the case next week, the hearing next week, I did file both. The Delta Police Department, whoever their court liaison is, sent me the officer's note, and that's all I received. She wrote in the letter, let me see if I can find it here, the response. I'm responding to your request for records for this violation ticket issued by Constable Cortez. Please find the enclosed general occurrence report and a copy of the electronic violation ticket.
Okay.
In your letter, you requested additional information. Constable Cortez will give evidence, will speak to those matters during the hearing as required.
Yeah, it's called
So that's what I got. Sorry?
Once again, it's in the damn name. It's called pre-trial disclosure. You're supposed to get it before trial so that you could actually prepare for trial. And something came up this week. I spoke to somebody and I couldn't believe the brazenness of, and this happened in front of a room full of people with prosecutors and defense lawyers, and nobody said a word. The judge was proudly discussing that some tickets had smiley faces on it and some had frowny faces. And no one said, objection, that's called ex parte communication. We didn't see that. These are things that are being communicated to the judge without your knowledge, which is why in the discovery request that you filed, if you got it from me, you want a copy of the police officer's original ticket that was filed with the court. You want the front and you want the back in case there's any notes on it. And in this little town in Texas, I think it's just so in the open and it's so understood. They just let it happen. Aber fungue, who cares about ex parte communication? Just tell the judge anything. So, you've got, I think, grounds for prosecutorial misconduct. They were supposed to give you that information before the trial. But while I have you here, before we're out of time, wow. What day is your trial? You want to look at the basics, the things that I was talking about in this show, the burden of proof, things like this. You have to, like what Laurence was doing, you have to keep the burden of proof and your focus on the prosecutor's claims. They have the burden of proof. If you stay focused on the burden of proof and you're asking good leading questions, and I recommend that we're trying to do the role playing on Saturdays after the show so we have more people participating, not tomorrow. So contact me on Skype at Frank Rizzo 3. So the basics are of keeping the burden of proof on them. Mac, you gotta assume that everything coming out of the lawyers' mouths and the cops' mouth are false, that they're just not true, and your job is to object and ask leading questions to get them to verify that crap that is constantly spewing from their mouth, okay? Which is demonstrably true, okay? Just like with this prosecutor that Laurence dealt with, oh, the Constitution, yes, is a written instrument, and it's a contract. So if somebody says something like that to you, you have to accept that this is false. This is just not true. And you do that not by saying it's false. You ask good leading questions. Are the necessary factual elements present here to prove it's a contract? Oh, they are. And how many elements are there in a contract? There are 4, right? And so these 4 factual elements exist here, and you plan on disclosing that and bringing that to trial to be able to prove your case beyond a reasonable doubt. So the 4 elements necessary for a contract, the most important one being a freely made agreement. This gets back, of course, to what I talked to before. How do we prove that the Constitution doesn't apply to us and doesn't create obligations? Because they're just men and women forcing us to give them money. That's it. It's either do what we say or go to prison. You're not making it's not a freely made agreement. That negates the whole concept that there's so that's what you do. You start deconstructing it. What it comes down to is we are asking questions to get to an understanding or have them to explain why they think that claim is true. What led, so let's say with a police officer. This is why nothing should surprise you. When you're doing a cross-examination on the police officer, you're asking him point blank. You determined on your own that just because I'm physically in Vancouver, that your laws apply and give you jurisdiction and probable cause. Right? It is called territorial jurisdiction. Again, it's in the name. Now, all we want to know, and the whole point of the cross-examination and being able to show that he doesn't know what he's talking about, is to find out what led him to believe that that was true. Is it credible? Does it prove? Remember, to be a witness, there has to be proof of personal knowledge of the matters that they're testifying to. If he's testifying the laws apply, and you violated them, he has to have personal knowledge of that. There is no exception carved out in there. Unless he's testifying to the foundation of the prosecution's case. I mean, come on. And I'm the scammer. I'm the one who's trying to put something over on everybody. That's all I gotta say about that. But you're asking it. So that's what the questions are geared towards doing. But you don't have the luxury during a cross-examination or if you're at a arraignment, if you're in a pre-trial conference, we don't have the luxury of time, so we can't ask nearly as many questions. You should know those questions and how to get to that point. But asking him what facts do you rely on that led you to believe that that was true is going to be sufficient to get them to start screaming objection calls for legal conclusion. The witness is incompetent to testify. And I've discussed this ad nauseum on the show. But it always bears repeating because we always have new people tuning in. And you shouldn't feel intimidated by what they're going to throw out at you. They're never going to be able to answer the facts question directly. You just have to deal with the garbage of their misdirection and their lies, such as jurisdiction's a trial issue only when it is clearly not. So just to break down again, when you ask for the facts that he relied on to make his decision that there was jurisdiction to stop you, and they say that that calls for a legal conclusion, you have to stress and object yourself and move for sanctions against the prosecutor because you didn't ask a question that called for a legal conclusion. This is a douche lawyer move. Only an idiot, even an idiot in a legal sense, would say that a question asking for facts calls for a legal conclusion. Even if I asked that police officer if he determined there was jurisdiction, that is not asking for him to draw a legal conclusion on the stand. You're just asking him to confirm what happened at the stop. And we all know damn well that's exactly what happened at the stop. So it's not necessary to get into Rule 701 and 702 opinion testimony. You can raise that, I guess. You can make that part of your objection, but it's not relevant to overcoming the objection because that's not what you're asking him to do. You are not asking him to give an opinion. You're asking for the damn facts that led him to believe that that was true. We're trying to determine whether his claim of jurisdiction is true. Is he a competent and credible witness as to the laws applying and you violating them? No. Absolutely not. And 99% of the time, even the prosecution says so. Then the judges say so. So don't worry that they can say something that you're not mentally prepared to address. So we can do the role playing to hell with that. But if you are rooted in logic, and yes, the claimant bearing the burden of proof is applicable in court, regardless of what some lawyers may say that principles of logic have no business in court. Of course they do. So knowing the burden of proof is on them, we're assuming that everything is a lie, and we're attacking the very foundation of their claim, which is that you're in Canada, the laws apply. You cannot prove the laws were violated beyond a reasonable doubt unless you can prove that they apply beyond a reasonable doubt. You don't do that with court opinions. You have to do that with facts and competent witnesses. So, I'm unfortunately out of time over here. I think we covered a lot of good ground. And we've got people like Mac in Vancouver who still are not feeling confident enough to be able to go in and do this. So I will say go to a city council meeting or county commissioners, someone there in Vancouver, and confront them and ask them the questions. Hey, you guys operate on the presumption if I'm physically in Vancouver, then your laws apply and give you jurisdiction over me, and that it creates obligations on me. Do you have any proof whatsoever that that's true? And that will help, at least mentally, so that when you go in to court, even though the risk is higher, you don't have to feel quite as much anxiety by going in and challenging these things. Again, the fact not appearing is presumed not to exist, and that which can be asserted without, and that which is asserted without evidence may be dismissed without evidence. So, appreciate everyone tuning in today for episode 108 of the big broadcast here. If you want to help support the show, it is much appreciated. MarkStevens.net and MarkStevens.cells.com. And I will be live on Saturday unless there's an issue there. But so whoever I may have missed, till then, salud.